Lately, we've been running a series of videos on criminal law in South Africa, whereby we are looking at the basis for criminal liability. So this is one video which is one in that series of videos on this theme on criminal law in South Africa. Thank you very much for being part of today's session. I certainly hope that you will find it very informative as we move forward to look at other issues related to this. Maybe just as a way of recapping, in our series we have spoken about elements of criminal liability, whereby we look at the act or conduct. This is the current edition. Then we have compliance with the definitional elements, and then we have unlawfulness, and we've got culpability. All these being significant aspects, or rather elements, that constitute criminal liability. In other words, they are prerequisites for criminal liability. Before one can be convicted, all these factors must be present. Thank you very much for taking part. Let's move on quickly to look at what we mean by a human act or conduct. You will recall that we've said elsewhere that law does not punish thoughts, but it only punishes acts. Criminal liability does not arise only when thoughts are harbored, but when the thoughts get manifested through human action. In other words, you can harbor as many wicked thoughts as you want to, but if you do not manifest them, if you do not go out to carry out acts on the basis of your thoughts, it remains impossible for the law to catch you until you begin to maybe vocalize them, speak to some people about them, which constitutes an attempt, or in some cases when you take steps in order to commit that act. Then those thoughts spring into relevance, as revealed by the fact constituting what we sometimes call inchoate or incomplete crimes, which then include criminal attempts. You know that attempted crime gets to be punished. It's not as innocent as just your thoughts. Rather, it's not beyond the reproach of the law as the thoughts that you harbor in your mind. Once you begin to take steps, then you are on the verge. You set yourself up for prosecution, if one could say. What is an act? What is an omission? You'll notice that this word act or omission, or these two words rather, refer to an act in criminal law. So both the act or an omission to act are referred to as act for purposes of criminal law. And we're saying an act refers to a voluntary human conduct, which includes omission. Well, the word act is a technical term of art, wide enough to encompass failure to act, which we have already referred to as an omission. So an act consists of a commission or an omission. When a person goes out to carry out positive action, it is called an act. Sometimes when a person desists from doing something, it is punishable in exceptional circumstances as an omission. We will look at those circumstances as we go down. It's very important that the inclusion of omissions in the definition of act is based on the fact that the punishment of omissions is an exception rather than as a rule. So we tend to talk more about an act, and then an omission is just appended there, just as an appendage of an act. And we are saying one of the requirements of an act is that it must be voluntary, and it must be undertaken by a human being. Animal acts instigated by humans are attributed to humans who are deemed to have committed crimes through the agency of these animals. Take an example of somebody who sets a dog to bite a human being. That kind of action, the biting is done by the dog, but the edging or the setting up is done by a human being. So, as was revealed in the case of Eustace in 1948, such an act is punishable. It's attributable to the human person, and it's punishable as if, the human person is the one who had carried out the biting. So, by doing, in other words, it is assumed that the human being or the person has carried out that act through the agency of the dog or the animal in question. So an act is a voluntary, which means one exercises their volition and go out to carry to do that which they end up doing. It's not forced upon them. So a voluntary act is not necessarily a willed act. It doesn't mean that one is willing to do it, but the fact that one goes out to do it, it means that you see, if it is done not by because the person maybe is used as an object by another person, but rather because the one carrying out the act does so voluntarily. So we are saying, in other words, he has full control of his or her mental faculties, is in control of the muscular movement during the commission of the act. Therefore, it is assumed that it is a willed act. In fact, not a willed act, but it is a voluntary act. Now, you see, it's different from a control from an involuntary, act whereby one's muscular movement is subjected to another external force. So it is in this case voluntary in that it is controlled by the will. You see, of course, control by the will is not always a prerequisite in crimes which require negligence, but rather intention as a requirement for culpability. We are going to explain that when we look at in one of our videos, not this particular one, where we look at culpability as an element of liability in criminal law. Voluntariness is excluded by a number of factors. We have mentioned here absolute force as well as relative force. Now, what we mean by absolute force, which is sometimes called vis absoluta, it occurs when X is deprived of the ability to control her will and intellect. Take, for example, a scenario where, a person much stronger than X pushes the hand of X who's holding a knife and then ends up stabbing Y who is adjacent, who is close by. So whilst it is X who was holding onto the knife, the fact that X's hand was grabbed by somebody else much stronger and then pressed the hand against a Y, causing the stabbing and the killing of Y, it excludes, rather, in fact, the act is an act in respect of X is excluded when Y grabs that hand of X and uses it to commit the offense. It is not X who has stabbed Y in this particular instance, but it is the one who grabbed the hand of X and used it to achieve that outcome who is responsible. So we say that absolute force that was that acted upon X causing, rather, turning the body and the faculties of X to be used as an instrument by somebody stronger. So absolute force is distinguishable from relative force, which is called vis compulsiva, whereby one is threatened with harm if he or she does not commit the act instructed. For instance, look at a scenario where Y threatens X that if X does not kill Z, then Y will kill X or his family. And if X yields to Y's threat and goes ahead to kill Z, it's an example of relative force, as was reflected in the S versus Goliath case in 1972. In this scenario, you find that X still has a choice whether to go ahead and commit, or rather carry out the instruction being given by the one who is exercising that relative force. But at the end of the day, in this case of relative force, conduct or act is not excluded, but it is imputed upon X, because X still remains with the choice between suffering the harm or committing the act, and thus he chooses to commit the act, which means, in a way, the act of rather the killing of Z in the particular scenario above is actually done and completed by X, in spite of the fact that there was compulsion. So compulsion does not exclude liability. X commits the act and can only plead the defense of necessity to escape liability. In other words, X cannot claim that she did not act in this case. She did. So relative force and absolute force are very different. Even the legal consequences are not the same. There are factors that exclude voluntariness. An involuntary act is one in which the actor doesn't have control. So natural forces such as hurricanes that is, actually exclude voluntariness. In fact, they even exclude the act itself. Take an example of a hurricane that blows through X's farm, destroys his house, and the debris from his house then kills Y's goats while the rest in the crawl. Y cannot hold X accountable because X did not do anything. And then, so we're talking here about voluntariness as a very significant requirement. What about acts of automatism, which is a kind of mechanical activity often induced by unconsciousness? We have sane and insane automatism. By sane automatism, we are talking about a person who acts in a mechanical way due to reflex action resulting from maybe sudden heart palpitations, sleepwalking or somnambulism, total blackout, unexpected, or hypnosis, or epilepsy, or any other maybe intoxication included, as well as provocation, if one would say. That person is completely sane, but because of maybe this sudden occurrence of a seizure of some kind, they are not able to take control and exercise their full faculties, that is their bodily faculties. So it is a kind of automatic activity. It is involuntary lapse of consciousness, and because the person does not have self-control, that kind of automatism then excludes voluntariness. Yes, you may say X has acted, but certainly the act was not voluntary. Then we have insane automatism, where you find that a person suffering from a mental illness somehow goes on to commit an act. If it can be establish that the person indeed suffers from a mental illness, that person clearly has acted in automatism, and the court undertakes an inquiry in terms of section 78.6 of the Criminal Procedure Act, and the result is a committal in a mental institution. But in the case of saying automatism, there is no committal in an institution of any kind if it can be established that indeed X acted in an automatic fashion, then there will be, discharged without consequence. Because indeed, if it can be established that they did not carry out a voluntary act, then liability in that respect does not arise. It is very important for us to note that the defense of automatism does not succeed easily, because desperate accused often resort to send automatism as a last resort. So courts tend to treat this defense with circumspection, very suspiciously, and it remains now for the accused to provide a basis for the defense by placing relevant evidence such as medical reports or calling expert witnesses just to demonstrate and confirm that maybe indeed there was automatism that he was subjected to. The purpose of the evidence is obviously to introduce a doubt regarding whether the act was voluntary or involuntary. But remember that antecedent liability presents a hurdle to the defense of automatism. If the accused had a prior knowledge of the possibility of an automatic reflex, such as epilepsy, maybe they've suffered epilepsy before, but went on to undertake the act that could have aggravated the resultant automatism, then the defense of saying automatism does not avail to such an accused, because it is taken that they volunteered themselves into that kind of scenario, knowing fully well that there was a high possibility of it happening. And omission is the next thing that we look at. We've been looking at a positive act, and now looking at an omission, we establish that it is defined as an act in criminal law, even though it connotes a failure to do something. Whereas positive action is a commissure, lack of action is an omission. And liability from an omission arises when one fails to act in spite of an existing legal duty to act positively. There are certain circumstances where there would be a legal duty to act positively. This issue was discussed in the Minister of Police versus Ewells in 1975, where the court noted that a person is not under a legal duty to protect another person from harm, even though they are able to, even though there may be moral expectations for them to. But of course, we know that failure to report a crime, of course, is not a crime in itself, except in those crimes which involve the abuse of minors, where they have to be protected, and the one who stands in a protective relationship must of necessity protect the minors. We have the example of a school principal who fails to report sexual abuse of children by a teacher. Such a principal is very irresponsible, and such a failure may actually result in criminal liability on his part or on her part if it's a woman principal, whoever it is. Now, there are examples of this legal duty, examples of scenarios where a legal duty arises. We have an example of a duty imposed by a statute. For instance, a person who obtains a firearm license and eventually obtains a license. is expected to keep that firearm under lock and key, inaccessible to other people. If that person fails to protect, to secure the firearm, maybe just leaves the key lying around, and one of his family or one of her family members takes that firearm and causes injury to other people, that person has actually violated the statute. And in terms of the statute, the legal duty to secure the firearm and keep it away from those who are not authorized to use it has actually been violated. So it's a duty arising in terms of a statute. What about a legal duty arising in terms of common law? Take an example of a crime of treason, whereby a citizen becomes aware that some members of the society are planning subversion, they are planning to overthrow the government and the state, and does not report that. Failure to report treason is a common law of offense arising from that common law legal duty to act. We also have a duty arising in terms of an agreement. For instance, a security officer who agrees that they are going to be opening the gate or closing the gate, what you call this boom gate, by the railway crossing, and then somehow the security officer absent-mindedly leaves the gate, the boom gate open, and then leading to an accident at the crossing, whereby the train maybe hits a motor vehicle. That's a legal duty arising from a written undertaking or a previous undertaking or agreement, and it can result in liability. A prior acceptance of control of a potentially dangerous object can also lead to that kind of liability. Take an example of somebody who keeps a black mamba in their property, within their property, and then it strays out to the neighborhood and bites and kills people. The person who undertook that prior acceptance of control of the black mamba is actually responsible for the killings that they have taken place. And then, of course, we have people that stand in a protective relationship. We've spoken about the school principal. Parents also stand in a protective relationship. If one spouse becomes aware that the other is abusing their children, then there is a duty to actually report the abuse of children. Failure to do so by one spouse would actually make them liable, because they have a legal duty to protect their children from harm. It doesn't matter who is causing the harm, even if it's one of the parents. And then there's also a duty arising from a previous positive act. Take an example where you make a fire to warm yourself out there in the jungle, and then when you leave, instead of putting the fire out, you just walk away like that, and then the wind comes and blows the flame, and then the whole forest catches a fire and people's properties are damaged and wildlife is affected. That's a criminal offense. The duty arose from the fact that the previous positive act of setting a fire, making a fire, actually imposed a duty to make sure that you put out that fire. So failure to do so is a serious omission. And then there's a duty arising in terms of the office that one occupies. If you occupy a certain office, like maybe the office of a police officer, and then you fail to protect people who are exposed to criminal activities, then in a way you are neglecting the legal duty to act. That was exactly the focus of the Minister of Police versus Ewell's case in 1975. And then in some instances, of course, we wonder whether conformity with the morals or the bony morals of society and its convictions should actually result in a legal duty. And this one is very difficult to resolve. But just maybe think of a scenario where an athlete, a very able-bodied man or woman who knows how to swim, stand aside just a few meters away from a swimming pool while a baby is drowning. Fair and fine, they may not have a positive duty to protect that child, but would society not expect that to take place? Maybe it may not be a legal duty as such, but certainly there is a duty placed upon them to do something. But of course, such a duty which falls short of the legal imperative would then not result in liability. Maybe just as an example of a duty that may arise from a previous positive act. Leaving a motor vehicle with open doors, after which children enter and disengage the handbrake, causing the car to roll down the slope and maiming a passerby, is actually, you know, it's actually a ground for liability. How does that come about? By leaving the doors of the car wide open. One was in breach of a legal duty to make sure that the vehicle is not accessible, particularly to children. So failure to secure the doors, leading to children just walking in and then tampering with the handbrake and causing the vehicle to slide down, is actually a breach of a legal duty. A legal duty that is to protect those around you. And then, of course, there are defenses in accusations based on omissions. The first one is objective impossibility. When faced with a criminal charge based on an omission, the accused may plead impossibility, that is, saying it is impossible for a person, like it is impossible for a person incarcerated in a prison to appear in court or it is impossible for a lame person to save a drowning child. We spoke earlier about an athlete who is able-bodied, who watches while a child is drowning. But if in that scenario we had a lame person who is not able to move, we can't then expect them to have a legal duty to save a drowning child. After all, there is this maxim which says the lex non cogit ad impossibilia, which simply means the law does not expect anyone to do the impossible. So objective impossibility avails as a defense. And then it must be based on a positive duty. The legal duty to act must have arisen in terms of a positive duty on the accused. In other words, we said that if you make a fire, then there is a positive duty to extinguish that fire. So it is a positive duty. But what about somebody who goes fishing, and then there's a law which says fish of a certain size, that's a small size, should not be caught, so nets should be made wide enough to allow those little fish to escape. And then that fisherman or fisherwoman decides to use a very small net, and then says, because I was looking for a specific fish, it would have not been possible to exclude all the other smaller fish. that one doesn't really make sense. It was an argument that was raised in Rex versus Canesta in 1951, and it really does not have any feet or any legs to stand on. And the accused must not have been the cause for the impossibility. In other words, you do not cause impossibility, then turn around and use it as a defense. Very, very important to take note of that. Last but not least, the concluding remarks. This lecture outlined the four elements of criminal liability in law, and it defined the term act as a term of art which also includes an omission. It outlined the scope of the concept of the term act, and it disclosed the elements of voluntariness of the act. It defined the factors that include voluntariness, and then it outlined the concept of the scope. It outlined the scope of the concept of omission, and then it explained the meaning of legal duty, giving examples of the scenario where such a duty is owed. Remember those 8 or 9 scenarios that we listed, and then it unveiled the defenses that are available to the accused who is facing charges based on omissions. Our next lecture discusses causation as a definitional element of materially defined and result crimes. We've got many other videos, especially on this criminal law series, that I would like you to keep checking out. Thank you very much for being part of this session. My name is Philani L Ndlovu. Look forward to engaging again in future. Thank you. Bye-bye.